Okay, class, let's go to the next consequence if the dismissal is declared illegal. We are referring to separation pay. Now again, I would like to emphasize, we have to look at the cause of the dismissal. If the cause is just cause and the dismissal is valid, then there is no obligation to give separation pay. The only instance when there is amount to be awarded in form of financial assistance is when the discerning compassion doctrine will apply. Now, if the cause is just cause and the dismissal is illegal, then there is an obligation of the employer to give separation pay, which is 1 month for every year of service, as enunciated in the case of CRC Agricultural Trading and Rolando Katindig versus NLRC and Obias, December 23, 2009. On the other hand, if the termination is based on authorized cause and it is a valid termination and a valid exercise of management prerogative, then there will be an obligation to give separation pay. The amount of separation pay varies, as I discussed earlier, depending on the cause of the authorized cause. The only exception in which is closure due to business reverses. Legally, the award of separation pay is only an alternative to reinstatement, especially in the following cases. 1. I would like to reiterate, I want you to emphasize the following instances when separation pay will be awarded. 1. When reinstatement can no longer be effective in view of the passage of a long period of time or because of the realities of the situation. 2nd, when reinstatement is inimical to the employer's interest. 3rd, when reinstatement is no longer feasible. 4th, when reinstatement does not serve the best interest of the parties involved. 5th, when the employer is prejudiced by workers' continued employment. 6th, when the facts that make execution unjust or inequitable have supervened. 7th, this is the famous strained relation between the employer and the employee. 8th, in case of valid dismissal in authorized cause except closure due to business reverses. 9. In case of termination due to disease under Article 299. 10th, when the dismissed employee's position is no longer viable. And 11th, lastly, when the dismissed employee opted not to be reinstated. So those are the instances when separation pay may be awarded. So let's go over. 1. When reinstatement can no longer be effected in view to the passage of time. When the case has been decided for over 20 years, 30 years, definitely there could be some supervening event and the company or the position is not already there, the department has been dissolved. Another one, when reinstatement is inimical to employer's interest. If the presence of the employee is a threat to the property of the employer, then reinstatement is no longer advisable. Another scenario, when reinstatement is no longer feasible, and an instance would be when the employee has been incapacitated partially or totally, or when the employee died already. There could be an instance also that reinstatement does not serve the best interest of the parties involved, depending on the circumstances. Like, for example, if the parties have been filing cases against each other, so it will not serve the best interest. or the employer is prejudiced by the worker's continued employment. There may be circumstances where it is really ideal that the worker should not be reinstated anymore. Otherwise, the employer will suffer any kind of damage or humiliation. Okay, another one, when the facts that make execution unjust or inequitable have supervened. So, well, like for example, when the company already transferred or closed down due to business reverses, then there's nothing to reinstate, and the employer will just give separation pay. And the very famous strained relation. As I would like to emphasize, the strained relation cannot be alleged, but it should be proven by substantial evidence. In termination due to disease, we have discussed this one, that there is an obligation to give separation pay. And when the employee dismissed opted not to be reinstated, it is voluntary on the part of the employee, then the employee can ask for separation pay. Now, when it comes to just cause, the reason why there is no separation pay if the termination is valid, because it is based on the premise that the employee who committed misdeeds or wrongful acts should not be rewarded. The only exception is financial assistance, and unless if the circumstances so warrant. Now, we discussed back wages also. So it's but proper that you have to distinguish that with separation pay. No? When it comes to back wages, it is usually based on the computation of the period by which the wages of the employee were withheld from the time of dismissal up to finality of decision. On the other hand, separation pay is computed per year of service. It's 1 month or 1.5 months for every year of service, whichever is applicable, or 1 month or 1 month for every year of service, as the case may be. So it's basic. The computation for back wages refers to the length of time when the employee was prevented from working and whose wages were withheld. The separation pay is computed per year of service. So that's how you will answer it. Do not forget this landmark case of the repeal of Section 10 of RA 8042, the Migrant Workers Act. Originally, Section 10 of this law requires that in case of dismissal of an OFW, the award of separation pay would only be the unexpired portion of the employment contract, or 3 months for every year of the unexpired term, whichever is less. However, this was declared unlawful by the Supreme Court for being contrary to law and at the same time violation of equal protection. So now the ruling is that if the OFW is illegally dismissed, the OFW shall be awarded the remaining portion of the employment contract, the unpaid salary comprising the remaining portion of the employment contract. Regarding the rule that separation pay will be paid per year of service, what is the meaning of this? So, in the computation of separation pay, should be 1 month per year of service at the date of hiring up to the finality of the decision finding illegal dismissal and ordering separation pay. So that's how you compute separation pay. Same is true with back wages. It will be computed until the finality of the decision.